5 seconds to go. Start. The first part of the statutory provision, which uses the expression may, postulates that the power can be exercised at any stage of an inquiry, trial, or other proceeding. The later part of the provision mandates the recall of a witness by the court, as it uses the expression shall summon and examine or recall and re examine any such person if his evidence appears to it to be essential to the just decision of the case. Essentiality of the evidence of the person who is to be examined, coupled with the need for the just decision of the case, constitute the touchstone which must guide the decision of the court. The first part of the statutory provision is discretionary, while the later part is obligatory. A two-judge bench of this court in Mohanlal Soni Supra, while dealing with peri materia provisions of Section 540 of the Criminal Code of Procedure 1898, observed the second part of Section 540, as pointed out, albeit imposes upon the court an obligation of summoning or recalling and re-examining any witness, and the only condition prescribed is that the evidence so to be obtained must be essential to the just decision of the case. When any party to the proceedings points out the desirability of some evidence being taken, then the court has to exercise its power under this provision, either discretionary or mandatory, depending on the facts and circumstances of each case, having in view that the most paramount principle underlying this provision is to discover or to obtain proper proof of relevant facts in order to meet the requirements of justice. Justice S. Pandian, speaking for the two-judge bench, noted that the power is couched in the widest possible terms and calls for no limitation either with regard to the stage at which it can be exercised or the manner of its exercise. It is only circumscribed by the principle that the evidence to be obtained should appear to the court essential to a just decision of the case by getting at the truth by all lawful means. In that context, the court observed, therefore, it should be borne in mind that the aid of the section should be invoked only with the object of discovering relevant facts or obtaining proper proof of such facts for a just decision of the case, and it must be used judiciously and not capriciously or arbitrarily, because any improper or capricious exercise of the power may lead to undesirable results. Further, it is incumbent that due care should be taken by the court while exercising the power under this section, and it should not be used for filling up the lacuna left by the prosecution or by the defense, or to the disadvantage of the accused, or to cause serious prejudice to the defense of the accused, or to give an unfair advantage to the rival side. And further, the additional evidence should not be received as a disguise for a retrial or to change the nature of the case against either of the parties. Stop.